An Ontario judge laments spike in urgent "let's change Johnny's school" motions at this time of year. In a court decision released the other day, a Superior Court Justice of the Ontario Superior Court began the ruling by lamenting the spate of last-minute urgent motions at this time of year, in advance of the upcoming September start of a new school session. The Justice wrote that pre-Labor Day "let's change Johnny's school" urgent motion has come somewhat of an unwanted annual tradition in the family court. Sometimes it's just the school. Sometimes it's the city where the child is to live. Usually it involves an attempt to change little Johnny's primary residence from one parent to the other. In this case, there was a request to suddenly change the country where the three adolescents are going to live and attend school. Quite commonly, these motions arise when the access parent unilaterally decides that children shouldn't be returned at the end of a summer vacation. And invariably this leads to emergency motions and a flood of frightening and entirely untested affidavits and allegations. Why the frantic rush? A, because the selection of a child's school has so many implications in terms of long-term parenting arrangements. B, if a parent establishes enough concerns to justify quickly switching the child to the school in their city or neighborhood, that instantly creates a new status quo which will have far-reaching consequences. Judges rarely disrupt a children's enrollment once school year is underway. So even if the initial concerns end up being unfounded or overstated, once the child becomes settled in the new school, the court will be reluctant to further disrupt this vitally important aspect of the children's daily lives. D, so if you can win the school issue by Labor Day, even on a temporary basis, it has enormous strategic consequences for the parent. And E, even if more profound consequences for the child, and even more profound consequences. Lawyers know this, judges know this, and high conflict parents quickly learn this. So every August, sometimes even in September, judges receive the "sky is falling" motions, in which one parent suddenly insists that the problems, which may have existed for years, suddenly need to be resolved in days. Before the school bell rings, it's a lot to have to decide in a hurry based on incomplete information. Judges don't like being rushed, and they don't approve of brinksmanship. So while judges dealing with custody issues always have to consider the big picture this time of year, especially they have to guard against potential for litigation strategy to conflict with the child's best interest, we must be responsive to the real problems while at the same time discouraging transparent attempts to reset the status quo. Sometimes in a parenting dispute, when you ask, and you were asked, is it important for what you asked for? The court's comments set the stage for a detailed ruling that includes consideration of various allegations between the sparring parents. The father who was living in Ontario, and the mother who remarried and was living in Missouri with her new spouse. The father applied to the court to prevent the mother from relocating the children to Missouri, and among other things, raised concerns that the children might be exposed to COVID-19 related risk if they are forced to move. This part of the ruling should be read in conjunction with some of the other recent COVID-19 related rulings in response to emergency motions on the children's schooling brought by separated or divorced parents, including the recent case of Chase versus Chase that we just covered last week. Thank you for watching today. If you like this video, give us a thumbs up. Hit the bell to subscribe. You can share and comment to this video in the comment box below. We'll endeavor to answer everybody's questions and comments at the end of each week. Until next time, I'm Russell Alexander.